Hello, law students and legal practitioners. Today, we will analyze the case of Paris versus Commission on Elections, GR number 123169, decided by the Supreme Court on November 4, 1996. Let's begin. Here are the legal doctrines of the case. The term, regular local election, under Section 74(b) of the Local Government Code of 1991 refers only to an election where the office held by the local elective official sought to be recalled is actually contested and filled by the electorate. It does not include elections for positions unrelated to the office subject of recall, such as Sangguniang Kabataan (SK) elections. Statutory provisions on recall must be construed in harmony with the Constitution, particularly the mandate under Article 10, Section 3 for an effective mechanism of recall. Any interpretation that would render recall impossible or inutile defeats both legislative intent and constitutional policy. A literal interpretation of recall limitations that results in absurdity or negates the recall mechanism must be avoided. Courts must construe the law according to its spirit, purpose, and policy, and not merely its textual letter. The prohibition against recall elections within one year prior to a regular local election exists to prevent unnecessary disruption of governance and redundant electoral exercises, especially where the electorate can soon choose a successor in a forthcoming regular election for the same office. Here are the relevant facts of the case. Danilo E. Paris was the incumbent punong barangay of Barangay Pula, Cabanatuan City, having won in the 1994 barangay elections. In 1995, registered voters of the barangay filed a petition seeking his recall for loss of confidence. The COMELEC approved the petition, scheduled the signing, and initially set the recall election after determining that more than 25% of the registered voters supported it. Due to postponements and legal opposition by Paris, the COMELEC rescheduled the recall election multiple times, with the last date set on January 13, 1996. Paris filed a petition for injunction before the regional trial court, which was eventually dismissed. The COMELEC again moved forward with the recall election, prompting Paris to elevate the matter to the Supreme Court. Paris argued that the recall election was barred by the one-year prohibition under Section 74(b) of the Local Government Code because the Sangguniang Kabataan elections were scheduled in May 1996. He claimed that SK elections constituted a regular local election, thereby proscribing the recall election. The COMELEC countered that SK elections are not regular local elections within the contemplation of the recall limitation rule. Issue: whether the upcoming Sangguniang Kabataan elections constitute a regular local election that would bar a recall election under Section 74(b) of the Local Government Code. No, Sangguniang Kabataan elections are not regular local elections for purposes of the recall prohibition. Section 74(b) of the Local Government Code prohibits recall elections within 1 year preceding a regular local election. Statutory construction requires that this provision be read in light of its objective, to regulate the timing of recall without nullifying the recall mechanism itself. The Constitution mandates Congress to provide an effective recall system. Interpreting regular local election to include SK elections would effectively eliminate the period during which a barangay official may be recalled, thereby nullifying the recall provision. The Supreme Court held that a regular local election refers only to elections where the specific elective office involved is contested, in this case, the punong barangay position. Since barangay elections were scheduled in May 1997, not 1996, the January 1996 recall election was not barred on account of the SK elections. However, because the next barangay election was already less than 1 year away at the time of final adjudication, the recall had become moot. Thus, while petitioner's argument failed on the merits, the recall election could no longer proceed due to the actual proximity of the barangay elections. Thank you for listening and happy learning. Please don't forget to subscribe to the Legal Shepherd PH YouTube channel and click the notification bell to stay updated on newly uploaded cases and jurisprudence. See you again for our next case discussions.